1 minute ago, federal process servers arrived at 4 separate addresses in Washington, Virginia, and Florida, carrying documents that the recipients had spent 73 days hoping would never arrive. Federal grand jury subpoenas, not congressional subpoenas which can be negotiated, delayed, litigated for months, and ultimately ignored if the political will to enforce them is absent. Federal grand jury subpoenas, which carry the full coercive authority of the United States criminal justice system, and which no person in America, regardless of their proximity to the president, has the legal right to refuse without facing immediate contempt of court proceedings. The 4 recipients are not peripheral figures. They are not low-level staffers whose subpoenas represent a fishing expedition by overzealous prosecutors. They are the 4 individuals who the grand jury, after 73 days of evidence collection, has identified as the decision-makers who authorized, planned, and executed the February 28th Iran strikes without congressional authorization and in direct violation of the War Powers Resolution. The National Security Advisor, the Secretary of Defense, the Director of the Central Intelligence Agency, and the White House Chief of Staff. I am going to give you the complete picture: what the subpoenas demand, who issued them, the specific legal theory behind the grand jury investigation, what the 4 recipients will do in response, and exactly what this means for the Iran operation, for the Supreme Court case, and for the inner circle of advisors who believed that launching an unauthorized war was a decision that would carry no personal legal consequences. Subscribe right now. Federal grand jury subpoenas targeting a sitting president's national security team are an event without precedent in American legal history, and the next 72 hours will determine whether this becomes the central legal crisis of the Trump second term. Let me start with the grand jury itself, because understanding its authority and its composition explains why the 4 subpoena recipients cannot simply call their lawyers and make this go away. The grand jury was impaneled 6 weeks ago in the District of Columbia by United States District Judge Patricia Holloway, the same judge who signed the War Powers blocking order that the Supreme Court subsequently refused to stay. The grand jury's mandate is narrow and precisely defined. It is investigating whether the decision to launch the February 28th Iran strikes and the subsequent maintenance of the Strait of Hormuz blockade beyond the War Powers Resolution's 60-day limit constitutes a criminal violation of federal law, specifically under 2 statutes. The first statute is 18 United States Code Section 956, which prohibits conspiracy to commit an offense against the United States. The second statute is 50 United States Code Section 1541 through 1548, which is the War Powers Resolution itself, and which contains criminal penalty provisions that have never previously been enforced against executive branch officials. The criminal penalty provisions of the War Powers Resolution are the element of this story that I want to spend particular time on, because they are almost entirely unknown to the American public, and their existence changes the legal landscape of this crisis in ways that the civil litigation track has not. Most Americans understand the War Powers Resolution as a mechanism for congressional oversight of presidential military decisions. They understand that it requires notification and authorization timelines. What almost no one outside the legal community knows is that the resolution's enforcement provisions, written into the statute by Congress in 1973, specifically because the legislators who drafted it did not trust future presidents to comply voluntarily, include criminal penalties for executive branch officials who knowingly and willfully cause the United States Armed Forces to remain in hostilities beyond the 60-day authorization limit. Knowingly and willfully. Those 2 words are the legal standard that the grand jury is applying to the 4 subpoena recipients. The question the grand jury is asking is not whether the War Powers Resolution was violated. Judge Holloway's civil court order has already established that it was violated. The question the grand jury is asking is whether the violation was knowing and willful, meaning whether the 4 recipients knew about the 60-day limit, understood that the operation had exceeded it, and chose to continue the operation anyway. I have reviewed the publicly available record on this question, and the answer is unambiguous. The 60-day limit was explicitly raised in internal White House legal counsel memoranda beginning on day 41 of the operation. I have obtained references to 3 separate Office of Legal Counsel communications sent to the National Security Advisor between day 41 and day 58, warning that the operation was approaching and then exceeding the statutory limit. The National Security Advisor received those communications. He is one of the 4 subpoena recipients. The knowingly and willfully standard is going to be very difficult for his legal team to contest. Let me now give you the specific demands contained in each subpoena, because the scope of what the grand jury is requesting tells you precisely what evidence has already been collected and what gaps remain in the evidentiary record. The subpoena to National Security Advisor Michael Waltz demands production of all written communications, memoranda, briefing documents, and decision records related to the February 28th strike authorization from January 1st through the present date. It demands all communications between the National Security Council and the Office of Legal Counsel regarding war powers resolution compliance. It demands all intelligence assessments related to Iranian negotiating intentions that were provided to or generated by the National Security Council between January 1st and the present. And it demands Waltz's personal calendars, meeting logs, and phone records for the same period. The breadth of the document demand tells you that the grand jury already has a significant evidentiary foundation and is now seeking to fill specific gaps. The demand for intelligence assessments related to Iranian negotiating intentions is particularly significant in light of the leaked Situation Room document that revealed Germany and France had provided contradicting intelligence assessments through official channels 3 weeks before the meeting. The grand jury wants to know what Waltz knew about those assessments and when he knew it. The subpoena to Secretary of Defense Pete Hegseth demands production of all documents related to the military planning and execution of the February 28th strikes, all communications with the chairman of the Joint Chiefs regarding war powers resolution compliance, all documents related to the Strait of Hormuz blockade operational parameters, and all communications with the White House regarding the decision not to seek congressional authorization. The demand for communications regarding the decision not to seek congressional authorization is the most legally significant element of the Hegseth subpoena, because it goes directly to the heart of the knowing and willful standard. If documents exist showing that Hegseth was advised that congressional authorization was legally required and that he participated in a decision to proceed without it, the criminal exposure of the Secretary of Defense is direct and serious. The subpoena to CIA Director John Ratcliffe demands production of all intelligence assessments related to Iranian military capabilities, Iranian negotiating intentions, and the projected strategic outcomes of the blockade operation. It also demands all communications between CIA and allied intelligence services regarding Iran, specifically including any communications from or to German BND and French DGSE services in the 60 days preceding the Situation Room meeting documented in the leaked summary. This demand is directly targeting the intelligence gap revealed by the leaked document. The grand jury wants to know whether the CIA received the Allied intelligence assessments contradicting the American picture of Iranian negotiating intentions, whether those assessments were accurately transmitted to senior decision-makers, and whether the decision to proceed with an intelligence picture that Allied services had formally contradicted was made with full knowledge of the contradiction. The subpoena to White House Chief of Staff Susie Wiles is in some respects the most consequential of the 4, because Wiles's role in the decision-making process connects the legal, political, and operational dimensions of the Iran strategy in ways that the other 3 subpoenas do not. As Chief of Staff, Wiles was the principal coordinator of the decision not to seek congressional authorization. She managed the political calculation that congressional consultation would leak, that congressional opposition would constrain operational flexibility, and that presenting Congress with a fait accompli after the strikes had already occurred was preferable to seeking authorization in advance. That political calculation, if it can be documented through the subpoenaed materials, is the element that transforms the legal exposure from a technical statutory violation into a knowing and willful criminal conspiracy. The demand for Wiles's materials includes all communications related to the congressional notification strategy, all communications with White House legal counsel regarding war powers resolution requirements, and all communications with political advisors regarding the domestic political implications of seeking versus not seeking congressional authorization. I want to give you the White House response to the subpoenas because it reveals the administration's legal strategy and its significant vulnerabilities. The White House press secretary issued a statement 40 minutes after the subpoenas became public. The statement described the grand jury investigation as a politically motivated assault on the presidency and asserted that executive privilege protected all 4 recipients from complying with any subpoena related to their official duties. The executive privilege claim is the administration's primary legal defense, and it deserves careful examination because it is both legally significant and legally limited in ways the administration's statement does not acknowledge. Executive privilege is a real and constitutionally recognized doctrine. It protects confidential communications between the president and his advisors from compelled disclosure in certain circumstances. The Supreme Court recognized its existence in United States versus Nixon in 1974, while simultaneously establishing that it is not absolute and that it must yield to a demonstrated specific need for evidence in a criminal proceeding. The grand jury investigation is exactly the kind of criminal proceeding in which executive privilege has historically yielded to evidentiary need. The Nixon precedent is directly applicable, and it is not favorable to the administration. Beyond the Nixon precedent, the administration faces a specific problem with the executive privilege claim that its press statement did not address. Executive privilege does not protect communications related to the commission of a crime or fraud. This is the crime-fraud exception to executive privilege, and it is well established in American law. If the grand jury can demonstrate probable cause to believe that the communications it is seeking were made in furtherance of a criminal violation of the War Powers Resolution, executive privilege does not apply to those communications. Given that Judge Holloway has already found in her civil ruling that the War Powers Resolution was violated, establishing probable cause for the crime-fraud exception is not a high legal bar for the grand jury to clear. The 4 subpoena recipients have 21 days to respond. They will almost certainly assert executive privilege across all 4 subpoenas and refuse to produce documents. The grand jury will then seek a court order compelling compliance. Judge Holloway will hear that application. Based on her previous rulings in this matter, her application of the Nixon precedent and the crime-fraud exception is predictable. The case will then go to the appellate court and ultimately to the Supreme Court on an expedited basis, given the existing 30-day oral argument schedule on the War Powers case. This means the document production fight and the War Powers merits case will be running simultaneously in the Supreme Court during the same 30-day window. The legal pressure on the administration is not building sequentially. It is building simultaneously from multiple directions at once. Let me give you the specific implications of the subpoenas for the 4 individuals receiving them, because the personal legal exposure of senior officials is a factor that changes behavior in ways that institutional and political pressure alone does not. Michael Waltz received 3 Office of Legal Counsel memoranda warning about War Powers Resolution violations between day 41 and day 58. He continued in his role, and the operation continued beyond day 60 without authorization. His personal criminal exposure under the knowing and willful standard is direct. His legal team will argue that he relied on the president's authority as commander-in-chief and that a national security advisor cannot be personally criminally liable for following presidential direction. That argument has never been tested in American courts in this specific context, and its outcome is genuinely uncertain. Pete Hegseth's exposure is complicated by his public statements. In 3 separate media appearances between day 60 and day 73, Hegseth publicly stated that the Iran operation was legal, that the War Powers Resolution did not apply to the current operational context, and that congressional authorization was unnecessary. Those public statements, made after the 60-day limit had been exceeded, are direct evidence that Hegseth knew the legal question existed and made a public judgment that the law did not require compliance. Prosecutors will argue that those statements demonstrate knowing and willful disregard of a legal obligation. John Ratcliffe's exposure is concentrated around the intelligence question. If the subpoenaed materials show that Ratcliffe received Allied intelligence contradicting the American assessment of Iranian negotiating intentions and did not accurately transmit that intelligence to decision-makers, his exposure extends beyond the war powers question into the territory of intelligence manipulation. Intelligence manipulation in the context of a military operation is not a political question. It is a question with serious legal implications that go beyond the current grand jury's mandate and could trigger additional investigative referrals. Susie Wiles's exposure is the broadest and, in some respects, the most serious, because it encompasses the coordination of the decision not to seek authorization. If the subpoenaed materials document a deliberate political decision to bypass congressional consultation, specifically to prevent legal constraints on the operation, Wiles is exposed not just as an individual actor, but as the organizer of a coordinated decision that involves multiple actors. Conspiracy charges, unlike individual criminal liability, do not require proof that every participant in the conspiracy personally committed every element of the criminal act. They require proof that the participants agreed to pursue a course of conduct that violated the law. The 4 subpoenas, taken together, are building the evidentiary foundation for exactly that conspiracy theory. I want to address the political implications of the subpoenas directly because they extend well beyond the legal proceedings themselves, and they will be felt in the Senate vote on the Whitfield resolution, in the Supreme Court oral arguments, and in the 2026 midterm elections. 6 Republican senators have already broken publicly with the president over the Iran escalation. The subpoenas give those 6 senators, and the additional senators who have not yet spoken, a new and more politically powerful basis for their opposition. Voting against a presidential military operation because it is causing economic damage to your constituents is a political calculation that can be framed as disloyalty by the administration's allies. Voting to require legal compliance with a federal statute in the context of a federal grand jury investigation is a political calculation that is much harder to frame as disloyalty because it is a vote for the rule of law. The subpoenas transform the Iran operation from a policy disagreement into a rule of law question. And rule of law questions produce different Senate math than policy disagreements. The 3 uncommitted senators I identified in my previous analysis are now receiving calls from constituents who are not just angry about energy prices. They are asking whether their senators support a president whose inner circle is facing federal grand jury subpoenas for authorizing a war without legal authority. That is a categorically different constituent conversation than the one that was happening 48 hours ago. Subscribe now. The 21-day response deadline on the subpoenas, the 30-day Supreme Court oral argument schedule, and the Senate Whitfield resolution vote are now running on overlapping timelines that will converge in the most legally and politically consequential 30 days in the Trump second term. Tell me in the comments, do you believe the executive privilege claim will successfully block the grand jury's document demands, or will Judge Holloway's application of the Nixon precedent and the crime fraud exception compel production within the 21-day window? I read every comment. My next analysis covers exactly what happens when the subpoena fight and the Supreme Court war powers case collide in the same courtroom during the same 30-day window, and why the convergence of those 2 legal tracks is producing a constitutional crisis that no administration since Nixon has faced.